Good afternoon. We'll call this meeting to order. This is a regular meeting of the New Ulm Planning Commission, New Ulm, Minnesota. It's Thursday, April 27th, 2017 at 4:30 p.m. Item 1 would be to approve the minutes from the March 30th, 2017 meeting.
So moved.
Second.
Got a motion and a second approving the minutes as presented. Any other discussion? All in favor, say aye.
Aye.
Opposed, motion carried. Item 2, consider for approval the amended final plat of the Retzlaff First edition.
Hey, members of the Planning Commission, the applicant is John Retzlaff. Property owners are John Retzlaff and Patrice and Patrick McLuhan. The legal description for the property is found on the plat. Street address is 106 to 110 Monument Street. Property is zoned R1, single family residence district. Status of the plat is following a public hearing, the City Council approved the final plat with conditions at their March 21st, 2017 meeting. Since that time, a mistake was found on that plat, and that mistake necessitates that it be amended and approved by the Planning Commission and by the City Council. And we'll get into the specifics of that in the staff report. A lot of this information is going to sound the same since you've heard it twice already. The property is generally located north of Herman Heights Park and Monument Street, west of Harmon Park, and east of Clay Circle. Located on the property are 2 single-family residences and several accessory structures. The east, north, and west sides of the property have steep slopes. Property surrounding the area proposed for platting is zoned R1. The only means of access to the property is from the south on Monument Street. The surrounding slopes separate the property on 3 sides from the park and single-family land uses. For property tax purposes, Brown County has divided the property into 3 parcels. Previously, the Retzlaff family owned all of the parcels and access to the property was not an issue. The residence at 106 Monument Street has now been sold and necessitates the platting of the property. The plat will establish 2 lots and a new interior property line between those lots. The new property line will roughly split the driveway and then extend to the north to the existing property line. An access easement will be placed on the driveway and allow both property owners to use the driveway to reach their property. Both new lots will have frontage on Monument Street. Information on the proposed lots is provided. You will note Lot 1 is located at 106 Monument Street. That house was built in 1963. At the time this request was made, its size was 1.01 acres. In the approved plat that was done by the City Council at the March meeting, that lot size was then 1.11 acres. On the amended plat, it has been reduced to 1.1 acres. Lot 2, which is located at 110 Monument Street, that residence was constructed in 1950. The parcel size was 1.62 acres. In the approved plat, it was 1.52 acres, and that lot size has now been increased to 1.77. So if you look at the total acreage involved in this plat, we go from 2.63 acres to 2.85 acres. So that's one of the mistakes that we're in the process of correcting. The proposed lots comply with R1 zoning requirements. Comprehensive plan designates the property for low-density residential land uses. The comprehensive plan does not designate a park within the platted area. Utilities currently serve both residences on the property. There is 1 water and 1 sanitary sewer service for the 2 residences. Status of conditions required for approval. Number 1 was to provide an electronic file of the plat in AutoCAD 2000 or newer format. That file was provided. A new file will be required. I might note that that electronic file is the reason that we found this mistake. Number 2, pay the application fee of $210. That payment has been made. Item 3 was provide executed copies of an access easement and the utility service agreement. And a document has been provided addressing both of those issues. Number 4 is execute and record the deeds necessary to establish ownership of the parcels as located on the approved plat. That action is dependent on the approval of the amended plat. I might note that the house at 106 has been sold. And so when the plat is approved, there's going to have to be new deeds issued between the two owners kind of to the new property line, taking into consideration new property line. Okay, the plat changes. A previous plat of this property in 1953 failed to take into consideration the split of right-of-way due to the vacation of Monument Street in 1904. Monument Street was 60 feet wide. So in a typical street vacation, half of the right-of-way defers to one side of the former street, the other half to the other. And so in this particular case, the Retzlaff property should have received 30 feet of right-of-way. There was also a 1939 plat that failed to take into consideration that particular fact. So other succeeding plats in this general area did not note or correct this mistake. As a result, it is now necessary to move the east property line of Lot 2 of the Retzlaff plat approximately 30 feet to the east. So it moves down the hill by 30 feet. As a result, because of this change, we have different lot dimensions and different lot areas, as was previously noted. Attached is the amended final plat and an aerial photograph of the property. Staff would recommend approval of the amended final plat, subject to the applicant will provide an electronic file of the plat in AutoCAD 2000 or newer format. And number 2, the owners will execute and record the deeds necessary to establish ownership of the parcels as located on the approved plat. Note, the changes made to the plat are considered to be minor since they only impact one lot and one property line. The adjoining property owner is the city, and the impacted area is primarily steep hillside. For this reason, the staff does not believe it is necessary for the city council to conduct a public hearing on the amended plat. And so that would, if you recommend approval of the plat, that would be part of your recommendation as well. That's what the staff is recommending. That concludes the staff report.
Okay, what are your wishes? Any questions? Comments? Motion?
I make a motion to approve the final plat of the Retzlaff's First Edition with the conditions the city has put on it.
I'll second that.
Okay, we have a motion and a second approving the amended plat per the recommendations of the staff. Any other discussion? All in favor?
Aye.
Aye.
Opposed? Motion carried. Get myself back here to where I need to go now. Item 3 would be an oral presentation by City Attorney Roger Hippert on the duties and responsibilities of the Planning Commission and Board of Zoning Adjustment. Stage is yours, Roger.
Thank you, Chairman Hogan, Commissioners. Dave Schnobrick had asked that I briefly address all of you this afternoon. It's good to kind of get an update as far as the requirements, the things you should be considering when you're doing your job on the commission. This would apply to the Planning and Zoning Commission, also to the Board of Zoning Adjustment for people who are participating in that. I'm going to try and be brief in my comments here. Not going to be any pop quizzes when we're done, but just some general things you should have in mind. The commission, this commission and the Board of Zoning Adjustment are probably arguably two of the most important commissions that the city has. You've got a lot of responsibility in making some big decisions that can affect long-term property in New Ulm and its use. You're governed by state laws and by our city code. In general, the state of Minnesota has authorized the city to create the commissions, to do the work that you're authorized to do under our state law and under our city code. In doing this, there's, I think, three things that you should have read and be aware of. Most of the work that you do in the Planning Commission is supposed to be tied into the city's comprehensive plan. That's something that the city adopted in 2007, so it's 10 years old. Under the state law that authorizes the creation of this commission, it says that if in the future there are going to be any amendments or changes to that plan, that's going to be the responsibility of this commission. That process hasn't started, it's not underway, but at some point it should be. And that's going to be a huge responsibility. What you should do, if you have not already done it, is you all should read and be familiar with what's in our comprehensive plan. It's available online, or I'm sure Dave or other city staff could get you a copy of it. The reason for that is that the state law says that the decisions that you make are supposed to be consistent with the directives in our comprehensive plan. That's kind of your Bible. In addition to the comprehensive plan, the other two parts of our city code that you really should take the time and read through would be chapters 9 and chapters 10. And those are the ones that deal with zoning and with subdivisions. It's not the most exciting reading, but there's a lot of detail in there. And again, this is what governs the decisions you're supposed to be making. If you're not familiar with that, that's just like a doctor trying to practice without ever reading Grey's Anatomy or not knowing what a skeleton looks like. This is just basic. You gotta have that stuff in mind. In doing your job, of course, the major things you do is the sort of thing you were just taking action on, reviewing and deciding preliminary and final plats. In addition to that, there's matters like considering conditional use permits. One of the things about this commission and the Board of Zoning Adjustment that's unique among city commissions is that there's times when you have to act in what's called a quasi-judicial capacity. What that means is that you are actually coming up with some findings. You're looking at a given set of information that's presented to you, and then applying our code, the state law, what the terms are in our comprehensive plan. You make findings that this is something that would justify the issuance of a conditional use permit in this particular zone. Or if you're asked to consider a variance on the Board of Zoning Adjustment, these are reasons why the variance should be granted or denied. Those findings that you come up with are part of your report to the New Ulm City Council, who ultimately makes a decision on this. Depending upon what those decisions are and what those findings are, someone who is dissatisfied could take the matter further into court. And then those findings are very, very important. You have to have them to support the decision. And I think Dave and our city staff is very good at working with you on that to let you know these are these are your decisions, but these are the things, yes or no, you should be including in whatever your report and your findings are. So make sure that you're careful when you do those things. When you are considering matters before you, whether it's on something like a conditional use permit or a request for a variance, you have to have in mind what the law requires. Our code sets forth the criteria that have to be met before these things can be issued. You need to be familiar with that. I think for all of us, there can be a temptation to look at what an applicant is asking for, and invariably, he wants some relief because it's going to cost him money. That's not really a basis for granting this kind of relief. Or they want to get some relief because it's for their business purpose. And, well, for us to expand our business, to do our business, we got to change things. Whether it's this commission or the city council, we have a comprehensive plan. We have zoning ordinances. Those are the rules. Those are the law. If at some point the council is going to change our zones or something like that, that's a long-term decision that they should be taking a look at. But in the meantime, we can't be picking and choosing and gerrymandering. There's a reason why we have zones in place. And it's for the orderly development and use of the land in our city. That you aren't going to have a packing plant next to somebody's house. You know, they aren't always that extreme. But there are reasons these things are there, and your obligation is to follow the law. When you're presented with legitimate reasons that meet the legal criteria to deviate from that, that's what your authority is. That's the discretion that you're granted. But I really urge you to have that in mind, that there are requirements that must be met by any applicant before you decide to grant conditional use permits or to grant variances. So I think those are the main things that I want you to be thinking about. Again, it's a matter of kind of familiarizing yourself with what Chapter 9 and Chapter 10 are from our code, and also what our comprehensive plan says, so that when you're doing your job, you're doing it effectively, you're doing it the way you're supposed to, and the decisions and recommendations that you're making are going to be solid, and they're going to stand up if there's a challenge down the road, because you put the thought into it, you've applied your obligations the way that you're supposed to, and you've got a well-reasoned decision that's explained. So, I don't know, Dave, anything else you think we should be mentioning?
Let's say we have a I've got some questions. And if you have questions, please ask
Sure,
them.
please, yep.
If an issue comes before the city, or this group, and it's something where we don't agree with the policy, what is the appropriate role for this group to take with that policy or with that provision? Let's say that we require a 5-foot setback and we think 3 feet would work just fine.
Yeah, again, that's something that happens all of the time, and generally, you are supposed to be applying what the code requires. There are specific hardship situations, but, you know, picking and choosing, you're going to end up with a gerrymandered situation. In addition, and you know this, every decision you make, there's somebody out there who's going to consider it as precedent. And although every one of these is unique, and they're always driven by the facts, the next person, the next property owner, all they're going to know is that you did this for Joe, and why aren't you doing it for me? Now, there's reason that you have discretion. I mean, there certainly are true hardship situations. But it's something where you are supposed to follow the code. And if we end up with something where consistently a 10-foot setback is something that's really causing all sorts of problems, I guess that's the kind of situation where if the city decides to make changes to the specifics in the code, that's up to the council. That's something that they can do. And maybe things change. I mean, what made sense 10 years ago or 50 years ago, maybe it doesn't make sense anymore. But it's what you have to work with. You're governed by those things. One other thing I didn't mention to you, and I think you might be very well aware of this, for so many of these things in Minnesota, we've got what's called the 60-day rule. And that was passed by our legislature some time ago. And essentially what it means for a lot of local governments is when a citizen applies for some particular type of relief, in many, many cases, you've got 60 days to act on it. And if you don't act on it, they get it. Whether it's a good idea, whether it's consistent with what our code says or not. And the legislature passed that because I think they were concerned about counties or cities denying relief just by putting people off forever and never really dealing with it. And this requires answers to be made, decisions to be made within this 60 days. So it doesn't mean you have to rush to judgment, but the notion of, well, we'll just put that off till next month and keep putting it off and putting it off, it'll have consequences. So you gotta have that, and staff will let you know if there's a deadline issue or if there's problems, because sometimes you'll want to get more information. You might want the property owner, well, have you checked on this? Could you do that? Come back and talk to us again. But bear in mind that for a lot of these things, you gotta act within the 60 days from when they've filed their application. So we know when that clock starts running.
So,
If we have a request for some kind of a deviation from the code, and after we do our review, we decide we needed more information, is that considered taking action, or is it not taking action until we approve or deny?
Well, I think that's could be the basis for a lawsuit. If they're gonna claim that you're just trying to drag this out and you aren't gonna meet your 60 days, that's something that, could be a problem. I think depending upon the situation in the past, sometimes what we've done is deny it for, at the time, it doesn't qualify, but the person, if it's something where legitimately you would reconsider it, if you had information
Okay.
that would maybe change your mind, they could reapply. But you'd want to make sure that you're not going to let it happen by default if you're not really confident it's the right thing to do.
yeah, and the 60 days runs from the date of the application, when it's submitted here at City Hall, and it has to be a completed application, to the time the council takes action on the item. So it's not necessarily a recommendation from this body, it's actual decision by the city council. Now, one other
Before you leave that one,
Okay,
that by default, so that we hit that where nobody does anything, does the requester get whatever they requested
Yeah.
as accepted?
Yeah, yep.
Okay.
But Dave brings up a legitimate point, because I've seen that happen where, a lot of times when the property owner is filling out their application, they do not include everything they're supposed to. And, if the application isn't proper, that clock never starts running, and they're notified of that you aren't gonna play games with them. It's just, hey, you forgot to put this in, and we gotta have this information. But just because someone's filed a piece of paper doesn't mean they got 60 days on whatever wild idea they want to do. They've got to do it right, and they've got to get the form completed the way it should be.
and also, I think it's important to note that this body has the ability to look at the city code, the zoning ordinance, subdivision regulations, and make adjustments or corrections if you see areas that you don't think are appropriate, or that maybe we're generating a lot of variance requests on, or that you think maybe were good, 40 years ago, but no longer are warranted. So you can generate those kind of changes. Now, ultimately, the city council makes the final decision on whether or not to enact it, but you have that right to
Generate the request.
generate the request, to have the discussion, and then to make a recommendation.
Dave makes a very good point, because the way the state law is set up, the idea is these changes, the ideas for them would come from you. The council would have the right on their own, but they're just usually not going to get into it. You're the group that sees this stuff on a day-to-day basis, and, it's got probably the most intimate involvement working with the property owners or the neighbors. You know what's going on in the city, and if you see that, hey, this is just constantly a problem, maybe we should reconsider it. You've got the authority and almost the obligation, if you think we should amend this part of our code, to put together the proposal and then forward it on to the council so they could take formal action on it.
One more question. The city charter has a planning commission and they have a zoning commission. Do they have to be separate?
No, I think they could be consolidated. I think that's something that absolutely could be done.
And if we wanted to do that, how would we do that? What would the process be to do that?
Well, I think if nothing else, you have the same people appointed by the mayor to both committees.
Yeah,
That would de facto accomplish it.
we would have to amend the city code to make that kind of change. And in the zoning update that we have been working on now for, a considerable period of time, that's one change that staff has recommended, is that we take the Board of Zoning Adjustment, we take the Planning Commission, we combine them together, and we use one agenda that would consist of variances, rezonings, conditional use permits, plats, and handle it all at the same time.
Yeah, Mr. Chairman, that makes a lot of sense just for efficiency, for the people who are involved to not be duplicating meetings, because you do have the same individuals. It just would make a lot of sense. I don't know why they did that at the time, but, it's.
Well, I think originally, when they were set up, the Board of Zoning Adjustment by state statute could make its own decision. So you could approve or deny a variance, and it didn't go to the city council. And so that power was
I think there's
removed
still,
by the,
and I think there's still, in cities of the first class, I still think it's set up that way for the larger metro areas. So that would make sense if they used to allow that discretion, but it's not that way anymore. It has to go to the city council
Yeah.
ultimately for our city of New Ulm size, so.
Anything else? Comments, questions?
Okay, thank you for taking the time.
Thank you for
Appreciate
coming
it.
in.
Thank
Okay, yep.
So, moving on to item 4, status of revisions on the zoning and subdivision regulations.
yeah. It's been a bad month from the standpoint that there just have been too many other things to deal with. We really haven't been able to put a lot of time into that. We've made a little progress, but not as much as I'd hoped.
Okay. Item 5, received report on the city council decisions concerning the planning commission matters of April.
Okay, at the city council's April 4th meeting, they approved the zoning of the property to be annexed at 2200 US Highway 14 West as B2, which is Service Business District, and authorized the use of that zoning classification in the ordinance and resolution annexing this property into the city. And that's the National Guard property is the term I would use to describe it. At the April 18th meeting, they decertified TIF District H-8, that's the Highland Regency House. That district was originally established on July 16th. The developer was not able to meet the standards that were incorporated in the development agreement in order to receive tax increment financing, and so the owner elected to have the district decertified, which is, it ends the district. City Council approved a number of actions associated with the craft project and their receipt of assistance through the Minnesota Investment Fund. They are to receive $435,000 through that particular program. They approved 6 items. 4 of them were documents, and then there were 2 additional items that were taken as far as local contributions that are required in order to receive the grant. That project is going to provide 50 new jobs. To date, they've, or as of December 31st of this year, they have provided 86. They need to reach that 50 jobs by May 1, 2019. So what they currently have is more than enough, but the most important date is May 1st of 2019. That's when they have to be able to have that number. They also are required to make an investment of $20 million and provide proof of that investment. One of the local contributions to the project is the city is transferring to Kraft a 3.8 acre parcel of property situated between the Kraft plant and Tower Road. Tower Road is the street that takes you back to the wastewater treatment facility. And that's, ever since I started working for the city, whenever I would ask, what's the purpose of the city having that piece of property? And the response was always, well, we're holding that for Kraft. Well, now we're giving it to Kraft. Okay, different item. As part of the MnDOT project that takes place in 2018, it's from 7th North Street out to the Y. So it's North Broadway out to the Y. They're going to construct a trail from North Front to that location. MnDOT will not construct it unless someone agrees to maintain it. Nicollet County wasn't interested in maintaining it. Most of the trail is in Nicollet County, and so the city of New Ulm has agreed to that responsibility. And information on projected costs were provided to the council. And then at that particular meeting, there were 2 actions to annex the National Guard property into the city. That's it.
Okay. We have an additional item between 6 and 7 item. Mr. Snowbrick would like to
Yeah.
mention something.
But don't want to forget the Heritage Preservation Report. Yeah, I've been approached by an individual who operates, it's a group home type of facilities. And our city code currently allows group homes of up to 6 in the R1 and R2 zoning districts and up to 16 in the R3. And those numbers actually come from state statutes. And this particular individual would also like to provide services and programming for those occupants, and that's permissible since, at that location where they live, no problem with that. But they also want to open it up to people that don't reside there. And so what that does is it takes the group home from being a residential use to now being a business use. And we really don't have anything in the code that we've been able to find that covers that kind of situation. So, as the city attorney was just talking about, this is a situation where we would have to change the code to accommodate that type of use. And so this individual has requested an opportunity to appear before the Planning Commission to state his case for making this change. If you were agreeable to making that type of change, then the staff would proceed with the direction you've given us to make those changes to the city code. So there's a little bit of a process that would be followed, and it's going to take a little bit of time to accomplish this if it's something that you want to proceed with. But I think the first thing that we need to find out is this something that you think we should accommodate? And then secondly, where should this be accommodated?
Well, we're first gonna have to hear from them anyhow.
First, we're going to have to hear from him. So
They would do a presentation then, or what?
he's willing to do a presentation. And I indicated to him that planning commission meets on a monthly basis. And of course, he'd like to accelerate his schedule, and he asked if you would have an interest in conducting a special meeting to consider this issue. So we're not making a decision on his project, but more so on, is this an appropriate use to accommodate within our zoning code?
So we would be here for them to put on a presentation, but we would take no action, make no decisions.
Well, I think the only decision, or I think the most appropriate action for you to take is if you think it has merit to direct the staff then to, consider or identify how those changes could be made. You could decide that the request is not something that you think's appropriate and, then deny or direct the staff that you don't want to proceed any further.
Would that have to be an open meeting for everybody?
Oh, yeah.
Always, yeah.
I don't think there'd be a problem with it.
I guess, like I heard, maybe a special meeting. What's your thoughts on that? And are you open to a special meeting at another time or a
And the
certain day?
timeline for is critical for this gentleman, or for the company, or for?
I don't know. He just said that he'd like to accelerate the process as much as possible. And he asked if you would be willing to conduct a special meeting to discuss this issue.
Well, even if we decided to have a special meeting, aren't we required by 30-day or something to announce that we're having a special meeting, or is that?
No, we
No?
would have to go through the normal protocols of notifying the press
Okay.
and, posting it, yeah.
What's your thoughts? I mean,
Mr. Chairman, I guess I don't have a problem with it if it's, I wanna, let's hear them out.
okay.
I'm fine with it.
I would like to only make it a 30-minute process here.
Yeah.
We don't wanna have it dragged on, so.
Yeah.
So,
I'm fine with it. I would probably, if we're all in agreements, maybe we direct staff to have Missy make contact and put out a few tentative dates that may work and see if we can get enough for a quorum.
Would we need to make a motion to have this special meeting?
Yeah, that probably would be appropriate. Direct the staff to,
I'll make a motion to direct staff to schedule a special meeting to hear from this business or individual in regards to his potential project, and for us to consider and go from there.
I'll second that.
okay, we got a motion and a second requesting the staff to try to set up a special meeting. Discussion, I guess my question is as guidance to them, is Thursday at 4:00 or 4:30 a good time? I mean, for you guys, or?
I guess probably we have to look at what the schedule and see what this individual has, and I think we
For this
also have to
room.
look at the room.
yeah.
Okay, so we'll leave it open.
So I think staff's gonna have to put together a few dates.
All right.
That is correct, yeah. And I assume that afternoons works best for you, that noons or mornings is something that you want to avoid?
Afternoons work
Afternoons
better.
work
Yeah,
better.
Jeff can take us out for lunch then. Okay.
I don't care.
Any other discussion? All in favor?
Aye.
Aye. Opposed, motion carried. We need to back up to the heritage preservation, but we skipped over. Anything?
No, there was no actions required in a meeting this
Oh,
month.
that's maybe why we went by it so fast.
Could have been.
Any other comments, concerns, questions? If not, no further agenda, meeting adjourned.